Losing a loved one is incredibly difficult. Amidst the grief, you may find yourself facing an unfamiliar and overwhelming challenge, the legal process known as probate. It can feel like an impossible task when you are already dealing with so much. Our goal today is to provide you with clarity and compassion as we demystify probate court. Before we begin, please remember that this video is for informational purposes only and does not constitute legal advice. Please consult with a qualified legal professional for personalized guidance. When a loved one passes away, you might hear the term probate court. But what exactly does it mean? Simply put, probate court is the specialized legal system that oversees the administration of a deceased person's estate from start to finish. Its primary purpose is to ensure that outstanding debts and taxes are paid, and that remaining assets are legally and properly distributed to the right people. Probate court serves several crucial functions. First, if there is a will, the court determines its legal validity. It also officially appoints an executor, granting them the legal authority to act on behalf of the estate. The executor works under the court's supervision to identify, inventory, and appraise all assets, like real estate, bank accounts, and family heirlooms. The court then ensures that legitimate creditor claims and taxes are settled out of the estate's funds. Finally, the court authorizes the distribution of the remaining assets to rightful heirs and beneficiaries. If disagreements arise among family members or creditors, the probate judge resolves those disputes to keep the process moving fairly. A common misconception is that every single estate must go through the lengthy probate process. In reality, depending on the estate's overall size and exactly how the assets are legally held, you might be able to bypass the court entirely. Let's explore the most common alternatives. First is small estate administration. Many states offer a simplified, expedited process for estates that fall below a certain dollar threshold. Instead of formal court proceedings, inheritors can often claim their share using a simple legal affidavit, saving substantial time and court fees. Next are living trusts. By creating a trust and transferring your assets into it, those assets are no longer considered part of your probate estate. Because the trust legally owns them, a designated successor trustee can distribute the assets immediately to your beneficiaries, completely avoiding the probate court. Another highly effective tool is joint ownership with right of survivorship. If two people jointly own an asset, like a family home or a shared bank account, and one passes away, the survivor automatically absorbs full ownership. This legal transfer happens instantly by operation of law, requiring absolutely no probate. Finally, consider built-in beneficiary designations. Life insurance policies, retirement accounts like 401ks, and bank accounts structured as payable on death let you name exactly who receives the funds. Upon your passing, this money transfers directly and privately to your named beneficiaries, bypassing the probate system entirely. The probate journey begins with filing a petition. The executor files a formal request with the local probate court. This document asks a judge to validate the will and grant the legal authority needed to manage the estate. Next comes the notice to heirs and creditors. The executor sends formal letters to all beneficiaries. A public notice is also published in a local newspaper to alert unknown creditors, giving them a specific window to make a claim. The third step is a comprehensive inventory and appraisal. The executor locates and values all estate assets, like real estate and bank accounts. Professional appraisers may be brought in to determine the fair market value of complex items. Before assets are distributed, the estate's debts and taxes must be settled. The executor uses estate funds to pay off legitimate claims, medical bills, and income taxes. This must be handled meticulously to avoid personal liability. Throughout the process, the executor must maintain accurate accounting. This means keeping an exact ledger of all financial transactions made for the estate. A detailed report of income and expenses is presented to the court for final approval. Finally, it is time for the distribution of assets. Once the court confirms all obligations are met, the executor gets the green light. Assets are distributed to family members strictly according to the will or state law. The final step is closing the estate. The executor files a petition showing that all duties are fulfilled and asks the court for a formal release. Once the judge signs off, the probate process is fully resolved. How long does probate take? The timeline is highly variable, often lasting anywhere from a few months to well over a year. There are strict deadlines you must follow. For instance, in California, you typically have 30 to 90 days to file the will after a person's passing. Missing these crucial deadlines can complicate the process. Beyond time, probate also comes with its fair share of expenses. First, there are court fees. Every time you file a document or open an estate, you can expect to pay filing fees, which vary by state and county. Next are personal representative fees. Many states compensate executors based on the estate's value. For example, under Florida law, an executor might receive 3% for the first $1 million. You will also need to account for attorney fees, as legal guidance is often essential to navigate court requirements. Finally, there are appraisal fees to determine the value of real estate or valuable items, surety bond premiums to protect the estate from mismanagement, and various other expenses like accounting fees. All of these add up and are paid directly from the estate's assets. Finding the right court is your first step. Jurisdiction typically falls to the county where the deceased lived. Directories like probateus.com can help you locate the correct courthouse quickly. Once located, follow these expert tips. First, seek legal counsel. Probate laws are incredibly complex, and a compassionate attorney can guide you, helping to avoid costly mistakes. Second, organize your documents. Gather the will, death certificate, and financial statements early. Third, communicate with heirs openly to prevent misunderstandings. Fourth, keep accurate records. Every penny spent or received must be meticulously tracked. Fifth, understand your fiduciary duty to act in the estate's best interest. Finally, be patient. The probate process can take months or even years. Taking a deep breath and maintaining patience is key to navigating this journey successfully. How long does probate usually take? Typically 6 to 12 months, but complex estates can take years. What if there is no will? The court distributes assets according to strict state intestacy laws. Can you avoid probate altogether? Yes, mostly through living trusts, joint ownership, or beneficiary designations. What is the executor's role? They secure assets, pay remaining debts, and distribute the property. Do you need a lawyer? It is not mandatory, but highly recommended to navigate complex paperwork. What if you disagree with the executor? You can formally object in probate court if you have evidence of mismanagement. We hope this guide has brought you clarity during a difficult time. Remember, understanding probate empowers you to navigate it more effectively. If you found this video helpful, please give it a like, subscribe to our channel for more valuable information, and share your thoughts or questions in the comments below. And for more resources and to find local probate assistance, visit us at probateus.com. Thank you for watching, and take care.